This is the case of the State of Ohio versus Tyler Smith, case number 25 CR 42898. Present before the court is Mr. Smith, right?
Yes, Your Honor.
Represented by Mr. Shield. We have Mr. Goodyear from the prosecutor's office and Officer Fisher from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
All right, we have $500 in reimbursements, 138 days of jail time credit. Does that sound right to everybody?
Yes, sir.
It does.
All right, Mr. Goodyear, on behalf of the state.
Your Honor, as you know, the defendant pled guilty to 5 counts, the most serious of which is a felony of the second degree, trafficking in drugs. And there's a few things that are of concern to the state. As the court's aware from our pretrial discussions, initially we had made an offer of 5 years in prison to the defendant if he were to enter a plea. That 5 years would be a mandatory sentence because it would be on the felony of the second degree. And the reason for that, Judge, is if you look at the underlying facts here, you've got someone who sold drugs directly to an undercover agent and then was on his way to sell drugs again when he was arrested. And we have, in the 2 different dates involved here, we have roughly 73 grams of methamphetamine and over 14 grams of fentanyl. And just from my perspective, Judge, I think that this is not someone who is, I guess the best way I can express it is, I mean, I certainly understand that there are different variations of all different types of crimes. And there are some people that sell low-level amounts of drugs to feed the addiction that they already have. And so if you have someone with a gram or two of whatever the drug might be, they sell it, you can certainly see where that person may need some assistance beyond just incarceration to try and turn their life around or try and change their behavior. When you see someone with, particularly with 14 grams of fentanyl, you think about the number of lives that can be destroyed by the amount of drugs he was selling, in addition to the substantial amount of methamphetamine. And from my perspective, Mr. Smith does not fall in the category of someone that should receive some type of assistance beyond incarceration, because I think he's beyond that. I think he's selling because he's a drug trafficker. And I think that his charges in Hamilton County support that conclusion because, as you're aware, he has similar charges in Hamilton County pending right now. And I think if you look at his history, Judge, it would support what I'm saying as well. So from the state's perspective, Your Honor, you have someone who I think is, you know, we come to court all the time and we deal with people that are charged with felonies of the 4th and 5th degree of a lot of varieties: theft, receiving stolen property, possession of drugs, so many different criminal offenses that are fueled by people's addiction. And the way I look at this, and it's just, of course, just my perspective, but he's the one fueling it. He's the one doing that to society. He's the one that's selling that amount of drugs to people. And frankly, it doesn't appear like he has the ability to conform his behavior to society. And I think that whatever sentence he gets, he'll probably end up going out and selling drugs again. For that reason, Your Honor, from the state's perspective, a substantial prison sentence is appropriate in this case, and we would ask that you impose the sentence that we had originally offered, which would be 5 years in prison, and that would be a mandatory sentence.
Mr. Fisher, anything from probation?
Nothing further, Your Honor.
Mr. Shield?
Your Honor, my client's 33 years old. He has 3 children. There is certainly a history of drug use and certainly convictions for drug use. There is not, however, a record of trafficking, and in the controlled by, in the recordings, my client was asking the officers, "Are you sure you want me to spend every dime that I have to go get this?" He was trying to fuel his addiction. He was actually trying to, he had been in a rehab, or was right around the same time was trying to get back into a rehab facility, and literally used every dime that he had in order to try to buy this, to make a little bit of money to put a roof over his head so that he could then get back into rehab. I do see that there are grams of fentanyl, totaling them up here approximately 14, but nowhere near the amount, at least in the evidence sheets that I've been given. The methamphetamine looks to me to be only about 17 grams. Now, I'm not minimizing the conduct here. What I'm trying to say is it's not exactly the story of a drug trafficker. It's someone who was in a very desperate situation, deeply addicted to drugs, doing his best to try to mitigate that circumstance by any means necessary. And unfortunately, all of the surrounding circumstances in his life, everyone that he knows and the lifestyle that he knew was that he could make a little bit of money to put a roof over his head if he engaged in this conduct. In the course of discovery, there's a party who has a very nice Mercedes that was mentioned where some of these drugs came from. My client offered early on in this process to participate in trying to help the state get in touch with that person who I believe is the real drug trafficker here. My client is a victim of his own choices, his own addiction, but has a very deep and serious drug addiction problem, but is not a drug trafficker. That's one of the first things he told me when we first met was, if you look at my history, this is not my MO. I did this to try to put a roof over my head and get back into a rehab facility. He was near homeless at the time. He was given a form that the pre-sentence investigator told him to provide to the judge. He has written a written statement, I think both of which express a deep remorse here and a deep remorse for what led him to be in the situation that he's in, but also asking the court to consider a period of mandatory time, but then to put him into a program with a significant period of time hanging over his head should he violate any term of probation upon successfully completing that program. I think my client is in desperate need of drug addiction therapy. I think even in the pre-sentence investigation report, Talbert House has made some very strong recommendations as to his care. While some of his major depressive disorder and opioid use disorder may be in early remission based on where he is now, I think that a period of mandatory incarceration and then a true drug rehab facility would help him. And I do believe, after many months of talking to Mr. Smith, I do believe that he would be likely, should he do well in prison and not have rule infractions and do well in the rehab program, that he would be out on the street working and being a better father and a better husband and a better member of society. And I think everything that he is to provide the court with today would back up. That's where he is mentally today. That's what he would ask the court to take into consideration when fashioning a sentence.
Mr. Smith, you get the last word in all this. What do you want to tell me?
It's okay to read this.
Sure.
It says, Dear Honorable Judge Oda, I would like to take this time to address you and the people of the courts with my deepest and dearest apologies. For the crimes I have took part in, they were reckless, childish, and not to mention immature to say the least. I have hurt, misled, cheated myself and the ones that love me the most with my actions. The man, the dad, and the husband I know I am is not the man that I have been. Due to this behavior, I have neglected my duties to my loved ones, myself, and society. I have made my life completely miserable. I am well aware that actions come with consequences, and with the severity of mine, discipline comes hand in hand. I've had plenty of time to reflect on myself and want change, Your Honor. I choose different. I demand my life and sanity back, and I'm begging you for guidance and help. I'm asking you to give me an option to change my ways, choose a different path, and take control back of my life. Is prison necessary? Yes, 1,000%. Is a bare minimum prison sentence and a program fair? I believe so, and I'm hoping you can find it fit to be as well. I can assure Your Honor that selling drugs ain't the biggest issue, although it's a bigger picture. I can live without selling drugs, but I'm an addict with a disease, and I'm asking you for a chance to learn to live life without using drugs and to give me the opportunity to learn the tools to stop using and put them drugs down. You and everyone else would be proud of the outcome. Thank you.
So here's where we're at, Mr. Smith. You know, the general feeling of our state in these kinds of areas, the people support long sentences for drug traffickers. The legislators are continuing to make more mandatory sentences, longer mandatory sentences, especially when it comes to fentanyl, because I agree with Mr. Goodyear's assessment that this is a significant risk to a lot of people in my community, and it's got to stop. But I think there is a disagreement amongst smart people as to what the best way to accomplish that is. Some people say that long prison sentence is the best way to do that, to punish you and to deter other people from doing the same thing. I don't believe that that is the most effective way, Mr. Smith, because I think that there is a fallacy in that when you've been doing this for a while like I have, you see people on the backside of it who get out of prison with no skills and no accountability and nothing. So we have this blended sentence, which is available to us in this case, which I'm going to take advantage of. So I'm going to sentence you to 2 to 3 years on the mandatory prison, which is the F2. Ms. Croco, we did not give them the notifications. So we have two issues, Mr. Smith. The first of those is that you're going to receive an indefinite term on the Reagan-Toke sentence. So, Mr. Shield, if we could please take a minute to review the notification on the indefinite term Reagan-Tokes and the notification on post-release control. I'm confident that you have already talked to Mr. Smith about both of these. What I'm going to do is attach these to the sentencing entry. But if Mr. Smith wants me to read them to him, I will.
So what this allows the prison system to do is give you more time if you violate any rules or in term of the prison control system. It's an indefinite term, meaning the judge is going to give a sentence with a period of time that is indefinite, that it's not defined. It's not something that is being put on you right now. But if you violate in prison, then you would get, from the Ohio Department of Rehabilitation and Correction, you would get, based on your offense in prison, you would get your out date extended. So you'd get more time based on this law that was passed. It gives the prison system the power to do that. So instead of having the judge be the sole person who can give you a sentence, the prison system now has this power based on the indefinite time under this Reagan-Tokes law that the judge is, and we went over this previously, but the judge is going to issue a sentence here today. That doesn't mean it's the final control over your sentence. You have control in prison. If you do well, you will not be subject to these terms, right? Okay. If you don't do well, you will be subject to these terms, and this will extend your prison time. Okay. There's a post-release.
All right, so, I'm sorry, Mr. Shield, I didn't mean to interrupt. Are we good?
Yes, we're good.
All right, so with regard to the Reagan-Tokes indefinite term, that means you're going to get both a definite and an indefinite term. So you're going to receive a 2-year mandatory prison term on the F2. You're also going to receive an indefinite term of an additional year, which is 1/2 of that term. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections can, under certain circumstances, keep you up to the maximum penalty. That's all set forth on this notification. Do you want me to read this to you, or are you satisfied that you've been notified about the Reagan-Tokes indefinite sentence?
I'm satisfied, Your Honor.
Well, secondly, you're also going to be supervised by the Adult Parole Authority. This is only if you serve your entire sentence for anywhere from 18 months to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence, or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. Also, with regard to the second-degree felony, we have a mandatory fine in the amount of $7,500. We have $500 in reimbursements for the cost of drug testing. As to the third-degree felonies, I'm going to sentence you to 24 months in prison on each of these. Those will be served concurrently to one another, but consecutively to the time that you're doing for the second-degree felony. And in the fifth-degree felony, I'm going to sentence you to 11 months in prison. That is also going to be consecutive to the time that you're doing for both the F3s and the F2. So that means that you're going to receive a 4-year and 11-month prison term. I think a consecutive sentence is necessary to properly punish you, to protect the public based on your criminal history, and the overall sentence is not disproportionate to the conduct involved here or the danger posed by you, and we have 138 days of jail time credit. Anything else we need to do, or anything that I forgot?
No, Your Honor.
Your Honor, my client is asking if after the initial 2-year mandatory period, if that would be the appropriate time to file for the judicial release into
This sentence is structured, Mr. Smith, so that you are eligible for judicial release. So it's not a mandatory sentence, you are eligible for judicial release. When you are granted judicial release will depend upon how you behave yourself while you're in prison. Because the way I look at this case is, once the 2 years is over, the mandatory period, then the punishment part of the case is done. And then we're going to move to the treatment portion of the case and probably put you in some sort of inpatient facility for another 4 to 6 months. And then we'll see how you do. But if you can't behave yourself in prison, there's no reason to believe that you would be successful in a CBCF, and there's no reason to believe that you would be successful on the street. Might as well leave you in prison for as long as we can, get you as close as we can to Mr. Goodyear's original recommendation of 5 years in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. The 2 notifications on the attachment you can just keep. Those are yours. We'll attach a different copy to the sentencing entry.
Judge, I did have one question.
Sure.
If I didn't hear this, I apologize, but court costs and fees,
Yes,
are those imposed or waived?
the costs are imposed.
Okay.
Because it's all or nothing. If I do the mandatory fine and the reimbursements, I got to do costs.
Okay.
All right. Good luck to you, Mr. Smith.
Thank you, Your Honor.